Welcome to Rainier Avenue Radio World. We are celebrating Earth Day. Earth Day was yesterday, but no, not here at Rainier Avenue Radio World. Earth deserves more than a day, so we will have 5 days full of panel discussions, interviews, films, lectures, just a ton of stuff for you in so many different areas that make up this world called environmental justice. I am going to turn the mic over right now to Solid Ground, Building Community to End Poverty, and Celestine Berrysmith.
All right, thank you, Tony. We are so happy to be here this afternoon with Rainier Avenue Radio, and Solid Ground's Tenant Services Program is an amazing program that educates the community of renters in Seattle, surrounding areas of Seattle, all of King County, and to some extent, all of the state of Washington. So we are really happy to be here this afternoon. And again, thank you for having us. So this is Rent Smart, and it is general information for residential tenants. So you need to know that you need to be a self-advocate in your rentals because no one else is going to advocate for you. You've got to know, and in order to be able to advocate well for yourself, you have to have the information. So we're happy to provide that for you. Please, next slide. So, again, this is great information to have. Right. So, today's presenters are the Solid Ground Tenant Services team. That is myself, Celestine Berrysmith, the Supportive Services Manager at Solid Ground. And it is Edgar Aldrett, who is our bilingual tenant counselor. And then we have Crystal Caleb, who is our tenant counselor. We're again happy to be here today. Next slide. So we would like to offer you the opportunity to fill out a survey to tell how much you enjoyed the information that you were going to get here today. You can email the Rainier Avenue Radio and they will send out the survey and they will send out a copy of this PowerPoint presentation so that you will have it, and it includes live links as well. Next slide. We always appreciate the information that you provide for us with the surveys. Really appreciate you for that. So if you could also, in your email, put the city that you live in, that would be really helpful to us. Next slide, please. So at this point, I would like to introduce you to my bilingual tenant counselor, whose name is Edgar Aldrett. Edgar.
All right. Thank you, Celestine. Okay. So let me advance here on my laptop here. And we are looking at the agenda, as you can see there on the screen. Thank you. We will be starting off with some general information about laws, and then we'll be talking about some tips for tenants, some great information there for you folks here that you can take with you and kind of learn, keep in the back of your mind while you're renting out there in the world of Washington rental. And then we'll be talking about the housing search and tenant screening information, and followed by information about fees and tips. And then I'll be passing it along to my colleague, Crystal Caleb, who will be talking about landlord responsibilities, tenant responsibilities, information on repairs, and then we'll provide you some tenant resources at the end of the presentation. All right, next slide. So let's go over some general information here. Next slide, please. So as you can see on your screen there, we have the landlord-tenant law. Now, something to be aware of is, where can you find this information? Where are the actual laws located in Washington State? Well, they are located here on the Washington State Legislature. For those of you that are on the screen or online, you can see that on there. There's a screen grab of the location. And what this title is the RCW 59.18, and this is the Residential Landlord Tenant Act of 1973. What is RCW? Well, that's Revised Code of Washington. So anytime you see this code listed out there, RCW, that's what it's referring to. And this is where you can actually go and find the laws, not just landlord-tenant laws, but every law that pertains to Washington State University. They've recently revamped it, so it makes it a whole lot easier for you to just click or copy and paste the URL and get that information that you need. And even though there's a lot of legal jargon in there, if you just break it down slowly, you might be able to understand it a bit, or you can take it with you with an attorney or go to the library and you might have someone to help you interpret that information. All right, so as Celestine mentioned, the laws of Washington, well, the landlord-tenant laws are self-enforced. So it's a self-advocacy state, meaning both landlord and tenant need to self-advocate. So with that, that means the landlord can hire an attorney, right? So they have an attorney that they can just dump all that information and go after the tenant. But what about the tenant? What are they supposed to do? Well, there's organizations like us that are available out in the community that can help you. Reaching out, Tenants Union is another one that you can reach out to as well. And we can help provide you information and resources where to go so that you can become a successful self-advocate. And when communicating with your landlord, it is very important to provide these codes. So just be aware of that. That's why we're providing the location of where to access these codes. Because anything that you're going to be doing in writing, again, it's going to be in writing, you're going to implement these codes in there, and depending on what the issue that you're encountering. Next slide, please. Now, for those of you folks, namely here in the house, we live in the city of Seattle, well, most of us do, but their laws are slightly different, and they add added protection for tenants. So as you can see here on the screen, we have the SMC, Seattle Municipal Code, Chapter 7.24. That's where you can access this information as well, and SMC, Seattle Municipal Code. And certain codes may be enforced by the Seattle Department of Construction and Inspections, which is the code enforcement, and they have a division called Renting in Seattle that you can reach out to get assistance. And these also will be the codes that you implement when communicating with your landlord in writing. Next slide, please. All right, speaking of codes, we have one here that would be definitely beneficial to a lot of the tenants that are accessing this information today. So 59.18.230, what does that state? Well, it pretty much mentions that lease clauses that waive your rights could be invalid. What does that mean? Well, sometimes landlords like to sneak in on their lease contracts that if the tenant agrees and abides by this contract and by signing it, they waive their rights under the RLTA, which is incorrect. They cannot do that. The RCW 59.18 takes precedence over any document. So you're always granted these rights under Washington state law. And this applies to both oral and written agreements. Some folks that have a verbal agreement assume that they don't have any rights. That's incorrect. You do have a right, again, be it verbal or be it in written. And some examples here, that I've listed on here on the presentation, you can see if the tenant agrees to pay the landlord's attorney's fees. If that's implemented in the contract, that's illegal. It's not allowed. Late fees paid within 5 days of due date, that is illegal, because for those of you who aren't aware, if you're paying rent on a first, you have a 5-day grace period to pay your rent. So the landlord can start charging on the 6th day. And for those of us in Seattle, we've encountered this a lot. Pay rent payments through electronic means only, meaning through a tenant portal. And landlords like to push that and say, no, sorry, you have to pay through this tenant portal. No, you are allowed to not even utilize that tenant portal. You can always bypass it, even if they try to negate you from utilize or force you to negate from using it outside and force you to use it. And again, that is your right, and this applies to repairs as well, because it has to be done in writing. Next slide, please. All right, let's talk about some top tips for tenants. Number one, be proactive. It's always smart to know where to access this information. As we talked about, Washington State is a self-advocacy state. Number two, if you withhold rent from payment or over repairs, withholding rent over repairs, because that seems very logical to do so, correct? Well, unfortunately, the law states that you should be paying rent regardless, because what could happen is the landlord could come back and issue you a pay or vacate notice. And also the RLTA mentions that you should be up to date on your rent and utilities. But what if you are not able to pay your rent and utilities? Does that mean I'm not allowed to assert my rights? It goes on a case-by-case basis, and that's when you actually want to speak with an attorney to find out what your options are in that situation. Top tip number 4, communicating in writing. Paper trail is always going to be your best friend. Documentation. You always want to document every single communication that you have with your landlord and keep any document that the landlord issues you. You want to create a file. It could be hard copy or virtual, but as long as that you retain all those copies and communications. And instances where that might occur is you could ask yourself, would I want a copy? Would I want to document this later on, this conversation or what this offer is being given to me? Always. You always want to say yes. If an agreement is offered to you verbally, make sure that you get it in writing. You can always follow up with the landlord and ask, okay, regarding that offer you gave me when we were talking on this day and time, please can I get that in writing? You always want to ask everything in writing. And if you ask yourself, could I be blamed for this? What's occurred here? So yeah, you definitely might be blamed for it. So that's why you want to document that, just to verify that. And so we do hear a lot that landlords tend to lie quite a bit about that. So it's always best, again, to document all communication. Next slide, please. Now, what you want to do is view the actual unit that you're moving into and read that agreement before you sign anything. That's very important to understand that, because we understand that some folks are in a situation where they're between a rock and a hard place and have to find a place to live immediately. It's going to be tough to read that contract that you're going to be signing, but if you do have that luxury, it's always best to read that contract. And don't sign anything unless you are 100% sure that you know what you're getting yourself into. And the final tip we tell folks is keep your relationship with your landlord professional. Why is that? Well, because some folks do not realize that the housing market is a business transaction. Tenancy is a business transaction. Why is that? Well, you have two parties, one contract, both parties are bound to it. That's a business contract as stated in Washington state law. So think of it that way and behave that way with your landlord. Do not try to be chummy with them. And a lot of landlords tend to do that because they want to find your weakness. Yes, we do hear that. But it's up to you. It's your decision. If you ultimately feel comfortable doing that, yes, but we don't recommend it. Just make sure that you create your boundaries. Next slide, please. All right, so we're going to be talking about the housing search and tenant screening information. Next slide, please. All right, so the housing search. How would you go about doing that? Well, you're going to pretty much ask yourself, what exactly are you looking for in housing? Will you be looking to move in with a friend, or are you going to be moving in alone? Or would you like to be looking for an apartment or shared housing? That's another thing as well. And are you looking to sign a new lease with a group of other people? That's a tricky scenario in regards to that when you're moving in with housemates. The reason is if all of you agree to be signed on one contract, that's how it's going to be treated. Just remember that you will be viewed as a single party. That group will be one single party because everyone is bound to that. That means if anyone leaves, any of their other roommates, who's responsible for filling the missing funds there? Well, that's going to be the other roommates. They're going to have to figure out how to come up with a solution, because a landlord, they don't care. They just want to get paid. That's all that matters. So think about that if you decide to look for a room with roommates. If you're moving in where the landlord is living in that's something that you want to be aware of too, because according to the recent change in state law, that the landlord can issue a 20-day notice. just to terminate the tenancy, if you have a shared kitchen or a shared bathroom. All right, other things to look into is your budget. That's going to be the most important component, correct? So there are some options that are available for folks in communities, such as public housing, Section 8 housing choice voucher. Those are the HUD program-based MFTEs, excuse me, or the tax credit housing that's available in the city of Seattle and now growing outside the city of Seattle. There are some nonprofits that do offer housing as well. And then finally, the fair market rentals. Next slide, please. And here you can see these are in our area, in the King County area, we have the public housing authorities such as King County and Seattle and Renton Housing Authority. And then we have the HUD programs that are available that can be easily accessed by that information on your screen there. Those websites that are listed, you can find information about what type of housing is available at the moment or the vacancies. Next slide. And also low-income housing tax credit, that's available. We have these links here for you folks that you can look into. Hopefully you're jotting this down, and we'll send you a copy of this presentation as well. And then there's the MFTE properties that are available too. We have the link for here for the city of Seattle. They have a PDF that they constantly update every month with new vacancies that are available. And then for nonprofit affordable housing, you can reach out to 211. That's a great resource for all of the tenants in Washington, not just housing, but other resources available as well. And there's some links that are available on that webpage, including Solid Ground as well. So you can check with them, see if there's some housing available. Next slide, please. All right, and then we have the fair market housing. And as you can see there, we have Zillow, PadMapper, Hop, Pads, Zumper. These are some of the more common ones, apartments, apartments.com. Yeah, there's numerous other websites that offer information about housing. Some of the most common issues that or locations that people search for housing that we hear about is Facebook. Craigslist has now finally kind of tapered off a bit. But in regards to these last two resources, you want to be careful for scams. And we've been hearing a lot of people have been getting scammed on that. So just be careful out there. And some folks who aren't aware of this, but you can always find out who pays the taxes on the property that you're going to be renting. Now, why is that being offered? Because you can find out to see if it's a legitimate rental and if it's valid. And you can go by the King County Parcel Bureau to get that information. And that leads you down a rabbit hole trying to find out who is the individual that owns it, especially if you're trying to communicate with the landlord. Next slide, please. All right, so let's move on now to tenant screening. So yeah, that's a big issue right now. And there's a lot of things that do occur, and the one thing that does stand out is discrimination. So you want to be careful with that. And we do hear stories that does occur, and it's still happening right now, especially even asking for an application. So if that were to occur to you, it's best to document the scenario, and you can contact, for those of us here in Seattle, the Seattle Office of Civil Rights, SOCR, and you can file a complaint with them, but make sure that you do document everything so that you have proof to submit to the case manager that'll take on your situation. Now, when you're applying for a rental, when you're doing the application, just be aware that the landlord needs to provide the requirements that are needed in order for you to be a successful applicant. And they will access some personal information to conduct a screening, and they will utilize that information to either accept or deny your application. Now, something that the landlords need to, well, not all of them, but some of you, especially the bigger property management companies, and here in Seattle, they utilize a screening company. Now, with that, if they do utilize that service, they need to let you know who that they use to access your personal information or your rental history. And another thing is the tenant screening fees. So some landlords, what they tend to do is charge the tenant a larger amount than what they actually paid for. That is illegal. So they have to charge you what they paid for. And that's why you want to know who they utilize. And then you as a tenant can go do the search yourself and find out what the cost was for a tenant screening report. For those in Seattle, There's the first in time, so just be aware of that. That's fairly new. So depending how quickly that you apply to that rental, the landlord has to use the first in time law. So, and then you give the tenant 48 hours to respond, like, okay, are you going to take it or not? And if they don't hear you back within 48 hours, they go to the next applicant. So it's important that you do respond immediately. And again, if you're the first one, they cannot come back and say, oh, sorry, we just gave it away, and this happened in under 48 hours. That can be construed as discrimination. All right, next slide, please. All right, talking about tenant screening, we hear about some barriers that are available. So what landlords tend to utilize nowadays is the credit reports. And that's becoming more common. That ends up becoming the gatekeeper for a lot of landlords to kind of filter out the tenants that they want to get into the unit. And it's gotten very ridiculous, the type of credit they're asking for, the credit score, so which can be deemed as being unfair or even discriminatory. Now, what you can do is the landlord will request that information when it comes back. You can request to get that credit score report that you have received or the landlord received. So you want to get a copy of that. But what we tell folks now is make sure that you jump the gun before you submit an application and check to see if you can get information about your credit report and try to fix it. Or if it's not that great, what you can do is kind of build a resume around that and get some folks or references, right, from families, friends, employers, anyone that you know to vouch for you as a tenant and kind of build that up. So it'd be like a rental resume, so to speak. Next slide, please. Rental history is also a barrier that a lot of folks do encounter. The one that is very common is the eviction on a record. There are ways around that. Just be aware, if you have an eviction on your record, it's permanent. But there are ways to actually cover that. And what I mean by cover, I mean that you can request a document from a judge to cover that eviction if a third screening party is utilized. So which means that there's a process that needs to be done. It's called an OLD, is that document. So that's something that can help a tenant out in that situation, but it requires a lot of legwork. Hence why you want to speak with an attorney to find out what your options are. Criminal record, yes, in Seattle, there is an ordinance where if you do have a criminal background or criminal record, they cannot deny you solely based on that criminal record. But unfortunately, they can ask you. It may feel discriminatory when they do ask you, but they cannot utilize that reason to deny your application. So just be aware of that. Outside of Seattle, unfortunately, they could utilize that reason to deny your application. Here are some fair housing laws in regard to discrimination that I talked about. As I mentioned, there's the Seattle Office of Civil Rights, but for those of us outside the city of Seattle, you can contact the Fair Housing Center of Washington. Next slide, please. Sorry. A landlord cannot single you out from others that treat you differently if you're included in a protected class. And here, as for those that can view the screen online, you can see the list of protected class, but for the benefit of those on a radio, what does discrimination look like? Preferential advertising, steering, refusal to rent, unreasonable occupancy limits, exclusion of children, you do hear that, refusal to allow reasonable modifications, or just plain old harassment. And that can be viewed as discriminatory. Now, protected classes, you could always contact the Fair Housing Center or go to the website and they'll show you a list of that. Same thing with the City of Seattle. They have the list and even more protections against certain classes that are available, that are out there in the City of Seattle. Next slide, please. Okay, let's talk about fees and deposits now. Next slide. And I'm sure a lot of us are familiar with fees and deposits, very common. And the quotes that I got here I got them from the Attorney General's Office in Washington. What is a fee? Is the amount of money that a tenant pays to the landlord for his or her use of the unit. Now, some fees are mostly non-refundable and must be described in the agreement. Again, fees must be described in the agreement. What does that mean? Some landlords tend to charge tenants fees that are outside of your contract. That's why it's important that you read your contract, know what it states, and know what you're going to be paying. Now, under RCW 59-18-285, no monies paid to the landlord which are non-refundable may be designated as a deposit or as part of any deposit. So you can see there, it's separating the fees and from deposits on there. So fees are the amounts that you will not be seeing back. What are some type of fees? Late fees. We've heard all that. In the news lately, a lot of folks are being charged, and also it's being utilized to try to evict tenants. That has changed. City of Seattle, just be aware, $10 late fees per month, that's it. What about outside of Seattle? Well, it depends on what city you live in, so that's recently changed as well. Each city has their own ordinance and the amount of time that when I mean amount of time, the notices that need to be issued and the amount. Pets as well, and cleaning fees. Cleaning fees, if you're paying up front, the landlord cannot charge you when you move out. Just be aware of that. If they do, it's considered double dipping and it's illegal. Some fees are not legal, such as homeowners insurance, attorney's fees, or some other fees that you can be construed as being discriminatory. So again, you want to read your contract and see exactly what you're paying for. And deposits, let's move on to that. So as according to the Attorney General's office, it's the money that a tenant must pay before he or she moves in. Okay, hopefully you can read that on the screen, folks that are online. Looks like it's not coming in clear, but I'm reading it verbatim here. Most deposits are refundable, and some examples of deposits, such as a damage deposit, which I'll be talking about momentarily, and then pet deposits and cleaning deposits. In regards to pets, that's definitely a tricky issue. Next slide, please. Okay. And I'll be reading this from my presentation here because it's not coming out, unfortunately, online. All right. So a landlord in the city of Seattle, this is pertaining to Seattle, the pets information, a landlord can charge an additional pet damage deposit of 25% of 1 month's rent, and it has to be written in the rental agreement. And landlord can charge pet rent. So there's that. You're going to be paying for your pet. Again, folks, this is for the city of Seattle. When pet damage deposit per household, landlord may limit amounts allowed. And the pet non-refundable fees are not allowed in Seattle. As we talk about fees, yes, it's illegal in the city of Seattle. But what about outside? Unfortunately, yes, they can charge for pet fees. And a pet damage deposit. Well, here's something that folks, and this is for Seattle again, for those of you folks that are here, you can break that up in 3 equal installments. So it's a payment plan. A lot of folks aren't aware of that, oh, Seattle offers a payment plan for deposits and fees, rent. Well, yes, they do. And I'll be talking about that momentarily. Next slide, please. That's next slide. Okay, so the installment payment chart that you see here, this is what you can ask the landlord for before moving in, before signing a lease agreement. As you can see there, it depends on the duration of the contract that you're getting. So 6 months, you can break 6 months or more. You can request a security deposit and pet deposit broken up in 6 equal monthly payments, and fees can be broken up in 3 equal payments. And last month's rent can be included with the 6 months, six equal monthly payments. For those tenancies that are 30 days, about a month, to 6 months, that's 4. So that drops down to 4, but the fees can still be broken up in 3 equal payments. For those that are 60 days or 2 months to 6 months, it's the same with the 4 equal monthly payments, 3 equal payments for fees, but last month's rent is 4 equal monthly payments. And for those that are living month to month that have that agreement, it can be broken down to equal monthly payments for the security and deposit, and fees, 3 equal payments. Now, the caveat here is that the landlord needs to offer last month's rent. This is only applicable if the landlord offers last month's rent. And I'm not sure if some of you have noticed how it's changed already. Landlords are now asking first month's rent and deposit. Before it used to be first and last and deposit. That's a way that they're actually skirting this law, so just be aware of that. It's pretty tricky what they're doing, so just be aware of when you hear that, that's when you actually want to go, okay, so this is a type of landlord I'm going to be dealing with, right? I'm like, I don't know if I trust this, or let alone this place. Is it even worth it? Is it going to be worth the headache that you're going to be enduring? Now, no installments for deposit fees if the total does not exceed 25% of 1 month's rent. So that's the other way that they're getting around that if it does not exceed 25% of 1 month's rent. So that's why, it's a great deal. It's a lower amount. And like, okay. And if you try to ask for a payment plan, they'll deny you, like, sorry, that's less than 25% of 1 month's rent. Yeah, so as I mentioned, landlords have been being very creative, so we got to find another way to approach it and how to, attack them from another angle, as my friend says. Next slide, please. All right, so now let's talk about the security and damage deposit. For those of you that hopefully can read it, but if not, all right. So security and damage deposit. Well, we're all familiar with that. What is a security deposit? Well, that means that you're securing a lease. That's all that means. And what about the damage deposit? Well, they're asking the money to cover any damages that might occur in the unit. So something to be aware of when the landlord asks for a deposit. These are things that need to be readily available for the tenant. So that's why it's important to request a copy of that agreement before you sign anything. What should be readily available to the tenant before they turn over deposit? Well, one, that the terms and conditions need to be in writing, and writing, not online or digital, but in writing. They're supposed to be doing that. Hence why you see like 100-page lease agreement, like we're not going to print this out. You have to do it digitally. Another way of landlords skirting what the law is required and make more work for the tenant. And also, it has to state under which the deposit will be withheld and where it's going to be located. Also, what needs to be available is the checklist, the walkthrough checklist, right? That both landlord and tenant have done. Now, what landlords have been doing is they've been including that in the lease. Here's a checklist, you go fill it out. And you're like, or it's pre-filled out, and this is what I think it is. No, you want to push to request to do that walkthrough to see what the conditions are, because they're just going to come back and lie. It's very obvious. That's another flag to be aware of when you see that the landlord's offering that. Like, we got a tricky landlord here. All right, let's decide if you want to stay there. But anyway, that checklist is required under law to be present. And when you're doing that walkthrough, make sure that you document everything. Have a friend with you as a witness, so that will be helpful. Take pictures. We tell folks you can also do a video walkthrough, like documentary style, but be careful. This goes to court. You're going to have to submit your phone over as evidence. But what we tell folks and what we've been told by attorneys is print it out. Any still images from that video you're able to grab, you can print that out and submit it to the court as evidence. Notify tenant in writing where deposit's placed. As I mentioned, it has to be that financial institution. Now, as we talked about, there's a payment plan that is available for tenants in Seattle, but it's also available in Washington State, so outside of the state of Seattle. And that one is just very general, and something to be aware of, that when you want a payment plan implemented, you have to do it in writing and before you sign the lease. So you're going to make that request. It's like, okay, before I sign this, I'm going to want this payment plan instilled before I sign anything. Now, what is included in that the payment plan? Well, again, last month's rent has to be present. So it can include the non-refundable fees of deposits and last month's rent, and broken up in 3 monthly equal payments. Next slide, please. Okay, what your landlord can withhold from deposits. So we're moving on to damage deposits. So what can a landlord charge you for? Well, any damage that's caused by you and by invited guests. So if you're having a party, you want to be careful because if something were to occur that they do damage something, the tenant could be held responsible for it. If anything occurs like that, you want to make sure that you do take pictures, that you document that, include it even on the checklist as well. Just if you have that checklist, include it on there, let the landlord know that this is what occurred. But the actual onus and to actually prove that the damage was done by the tenant is on the landlord. So they need to prove that. And the deposit cannot be withheld for normal wear. So if the landlord tries to withhold any of your funds from your deposit and they're charging you for, say, that the carpet needs to be replaced, but it was already used up, it's worn out, curtains are dirty or worn out, the faucet handle broke, or the oven, something from the oven broke while you were using it under normal daily conditions, they cannot charge you for that. That's normal wear. And the landlord cannot charge any fees that is not in a rental agreement, as we talked about. Any fees that are going to be charged have to be on that rental agreement. And the landlord may be able to take unpaid rent or fees if it's in the rental agreement. And the landlord can charge cleaning fees at move-in, as we talked about. But at move-out, if you paid up front, you can't pay again at the end when you do move out. That's double dipping. All right, next slide, please. Okay, so getting your deposit back. That's a popular subject here. So at the end of your tenancy, what you can request is the walkthrough. You want to do the walkthrough. And is it required under law? No, unfortunately, it's not required under law, but you still want to request that from the landlord. Now, how does that all function? Well, you do the walkthrough again. You take pictures, you document everything, utilizing the same checklist when you first moved in. And once you're done, that both of you agree on the conditions of the unit, you sign it. Both parties need to sign. You get your copy. You provide your forwarding address. You turn in the keys, which is pretty much ends your tenancy. And then the landlord has 30 days to return your deposit or a statement. So it might contain charges on there, or you might get part of your deposit back. Here's the thing: you as a tenant, you can dispute any of those charges, and you're allowed to. Now, here's something that's new that a lot of folks aren't aware of, is that now the landlord has to provide proof of those charges, meaning quotes or receipts or any documentation that they're going to be withholding any of your money. And they cannot charge you for, say, paint, $500, or cleaning, like $200. They have to provide information of the company, of the labor cost, and of the materials that were utilized, all costs, all that detailed information. If they don't, you can always push back. And what is the recourse for tenants? Well, you can take them to small claims court. That is an option. And in King County, who handles small claims court? Well, it's not going to be downtown. It's going to be up in Wallingford by the King County Dispute Resolution Center. That's who handles it. So you can go to their website and you can do the intake with them virtually or email or on the phone, and they will help you out and guide you in a direction that what you want to set up a small claims against the landlord. Now, if the landlord outright refuses to give you your deposit and you know that you're in the right, you can also take them to small claims court, and chances are that the commissioner or judge will give you 2 times the amount of your deposit if you can show that the landlord blatantly refused to return the deposit. And remember, small claims for $10,000 or less, and no attorneys. So we all know, like Judge Judy type of program, that's pretty much what you're going to be encountering in small claims court. Okay, next slide, please. And with that, I'm going to pass it over to my colleague now, Crystal Caleb, who will talk about landlord responsibilities.
Thank you so much, Edgar. Hello, everyone. So glad to be here. All right, now without further ado, I'm going to paraphrase a little bit because I know that we're having some technical difficulties with our slide here. So I'm going to read off as much as I can for also those of you that are listening to us on the radio. Okay, so landlord duties. This is as described in RCW 59.18.060. Okay, this is a part of the RCW where, again, like Edgar said, you will find all of your local, city, and state laws. So your landlord has a responsibility or a duty to provide reasonable program for the control of insects, pests, except for when the tenant caused the pest infestation. Now, this is a little different because once you are, well, if you are a tenant renting a house, if you are found to be the cause of that particular issue that you're having, you will have to pay for that. So if you're in an apartment community, let's say, for example, you just report it to your property management team, and they should be able to send out a team for you to go in and check and see what the issue is and where the cause is. And then they should also keep the shared or common areas reasonably clean and safe. So let's say you're in a 55 and over community and there's some carpets that are tripping everyone over or any other types of objects in the way. You want to make sure that you report that to your community manager or the management and have them take care of those issues right away. All right, next slide, please. Okay, they should also keep the place suitable for you to always live in during your tenancy. Now, this also falls back on you as a tenant. You need to always make sure that you're reporting any issues that you're having with your unit or your home if you're renting a single family house. So just please keep that in mind. Just make sure that you're letting them know when there's things that are not up to date or as they should be during your tenancy there. And then they should also keep the place to substantially comply with all the state and local laws affecting your health and your safety. Going back to, making sure that there's no carpets that are, bulged up somewhere or tiles that are coming up from the floor or, things that could potentially create a health issue like maybe mold. There's a leak that hasn't been taken care of yet. So those are things that you should make sure that you're making your landlord aware of. And then they should also keep all structural components like your walls, your roof, your flooring, your chimney, those types of things in reasonably good repair. So let me give a really good example of that. If you are renting a house, for example, and the previous tenant used the chimney all year long or the fireplace all year long, and now that you go in the cold winter months to go and burn your fireplace and get it going, and it's Christmas time, let's just say, and you've got a buildup of creosote in that chimney and the smoke is just pouring into your home, that is an absolute no-no. So that is their responsibility to make sure that between tenants that is also being taken care of as well. You don't want that problem to make you sick, right? Okay, next slide, please. All right, so they should also make necessary repairs and arrangements to put and maintain the place in as good condition as the law or the rental agreement says it should have been at the beginning of your lease. Now, this is except for when the condition is due to normal wear, and that is something that has also been recently changed in the law as well. It is not wear and tear anymore. It is wear. So let's say, for example, you've been in your unit for several years and you're walking around, you're moving furniture around, things get banged up on the walls, they start coming up on the carpets. You want to make sure that you're not being charged for normal wear. Even your blinds, we open and close them all day long and all year long. So those have a tendency to start, falling off or being a little bit harder to open and close. So those are just making sure that you're bringing that to their attention as well. All right, now they should provide reasonably adequate locks and keys. So that is saying that you should not just have one little tiny latch making your door closed to keep you safe at night. So they should make sure that they're giving you deadbolts and that you are able to effectively lock your doors and keep your belongings and yourself and your family safe, right? All right, next slide, please. Okay. Now, your landlord also has the duty to keep all electrical, plumbing, heating, and other installations and appliances supplied by the landlord in good working order. If you have a refrigerator that's making weird noises or an oven that just won't stop smoking after it's done cooking, you want to make sure that you are making sure that you're letting them know that those are things that need to be looked at before they become a bigger issue. All right, now they should also keep the place in reasonably weather-tight condition. Washington State is extremely difficult in her weather, we'll say. So during the months that are really, really cold and breezy, you don't want any type of breeze coming through under your door or through your windows. So you want to make sure that you're letting them know that, hey, my rubbering around the ground, or not the ground, around the doors or the windows need to be replaced. I've got a pretty good draft coming in. I also don't want my heat bill coming up. So please come and take a look at that. That is really important, especially for us here. So make sure that you're letting them know that. And then they should also provide waste receptacles and a waste disposal service in the case, or I'm sorry, except in the case of a single family residence. This is basically stating that if you're living in an apartment community or a multifamily housing, they should provide large garbage receptacles outside and, might I add, have them regularly serviced. So if there's folds that are coming off or coming apart where kids are running by and knocking them over or playing with them where they could fall and create an issue, you want to make them aware of that. Also, they should have them picked up regularly as well. That also contributes to pest control. So you want to make your apartment community aware that, hey, we're not having our trash picked up like we're supposed to be. And now I'm seeing little critters running around the backyard area or by the office. That's an issue. So you want to make them aware of that. Now, if you're renting a house, however, that's a little bit of a different story. At that point, you are responsible for making those arrangements with the utility company that takes care of that. All right, next slide, please. Now, your landlord should also provide facilities adequate to supply heat and water, hot water as reasonably required by the tenant as well. Oh, excuse me. Now, this is saying that if you have a water heater in your unit, you should not hear any noises coming from it, and it should be running properly. It should be functioning properly. You should have hot water coming in at all times, unless if you've already depleted your hot water for the day. So you want to be careful with that as well. Most apartment communities have larger water heaters that are set in separate buildings, I would say. So just making sure that you're letting them know, and I'm going to emphasize on letting your property manager or your landlord know that there are issues going on. You live there more often than they do, so you have to make sure that we're keeping those lines of communication open as well. They should also provide a written notice to all tenants disclosing fire safety and protection information along with notice of smoke detecting devices. Now, in most leases, you will find an addendum that explains to you, or even a booklet that will let you know where the fire exits are, where the fire extinguishers are, who to contact in case of an emergency. And usually that's on the front door, or it should be on the front door of a lot of these apartment community offices as well. And then along with the smoke detecting device. Now, in RCW 43.44.110, it explains that the tenant is responsible for maintaining the smoke detector. So your landlord is responsible for making sure that they are in the unit and they are functioning properly before you move in. But it is your responsibility as a tenant to make sure that they work throughout the year. So I would say every other month, every couple of months, you want to check to make sure that it's still beeping. And that's just a quick test. You hold the button down and it'll make a couple of beeps and you're okay. Now, if your battery is out and it needs to be replaced, your smoke detector will make some chirping noises. And it is your responsibility, as it is in your lease, most likely, that you are responsible for maintaining that. So just a little side reminder. Next slide, please. Okay, now let's move on to some illegal actions of the landlord. Now, this is something that we really want to pay attention to here, okay? And I'm gonna explain as much as I can for those of you that can't see and that are just listening to us on the radio. So self-evictions, whether you are a private landlord or a large company, are not allowed. Now, the landlords are supposed to use the legal eviction process, meaning they can't just come up to your door and say, hey, I don't like you, you gotta go. No, absolutely not. They are not allowed to come and just let you know that you are no longer a tenant. They have to go through the entire process of notifying you for whatever reason, and they have to have just cause, which in the law in Washington State are 17 reasons. One of them being, let's say, for example, you're late on rent, or there's some criminal activity going on, or even they want to move into the house. If you're renting a house, they should give you a 90-day notice letting you know that in 90 days, I'm going to be moving back into my home. So at this point, I'm letting you know that your tenancy is going to be terminated. And then also lockouts, especially when you had no plans on moving. They should not go in and change your locks just because you owe money, or you didn't listen to them when they told you to pick something up from outside, or your car has expired tabs, whatever the case may be. They cannot change your locks, especially without a writ of restitution from the sheriff if it got to that point, if you were evicted. So absolutely no lockouts. If they also close or shut off your utility services, like your electricity, your water, your gas, absolutely not. That is also written in RCW 59.18.300. It explains in detail what that process looks like if they in fact do that. They also cannot take or sell property from a tenant. Let's use that again. If you are behind on your rent and you have a car sitting outside, well, you know what? I'm just going to take that car because you owe me $2,000. So I'm going to sell that car for $2,000. That's not yours. You can't do that. So yeah, absolutely. And it happens. So this is just really important that you are understanding that you're not just a renter, you're a person. So, you wouldn't expect for someone that you owe money to come and just take your stuff and sell it, right? So, all right. Now, another thing is they cannot require tenants to take on landlord responsibilities. That could be going up on the roof and replacing shingles. You can't do that. Or, a fence that you need to build because, well, I just want a fence around here. So I'll take a couple of dollars off your rent and I'm gonna let you just fix it. No, you are not the owner of the building. You're not the owner of the property. That is not your responsibility. That is the responsibility of the landlord themselves. They are the homeowners, right? And then finally, they cannot rent condemned property. So if the city had already shut that property down and they're still continuing to operate, it is highly illegal. And most likely you can, in fact, take them to court for that as well. And if that is ever the case, let's hope not. All right. Next slide, please. Ooh, okay, now retaliation. So for example, if you've already asserted your rights as a tenant and you told them, no, listen, this is what is going to happen. This is what you cannot do. And I know my rights as a tenant here in the state. And then they turn around and give you a rent increase, or they terminate your lease, or, they just hit you with all kinds of weird notices. That is considered retaliation, my friends. That is something that they cannot do in this state. And that is also outlined in RCW 59.18.240 if you're listening. It's a really good place to start with that. They also cannot enter your home without proper notice by law. All right? If in case they have to come into your unit, let's just say you live on the 3rd floor, and you went to work and your dog or someone or something bumped into let's say maybe the shower handle. something that's really easy to move around. And now your apartment's flooding, and now it's traveling downstairs to the neighbors below you. That is considered an emergency. That is when they can, in fact, go into your unit to make sure that you are not or that unit or that problem is not creating any further issues. So that is when they can go in, or if there's a fire of some sort, things of that nature. Otherwise, 42 hours, I said that so confidently, 48-hour notice is what they are supposed to give you by law. 48 hours to let you know that they are needing to come into your apartment or your home for whatever reason. They need to inspect, fix things, but they should also make sure that they're giving you at least time frames or a window, all right? Now, they cannot also increase monthly housing costs without notification. Now, this also depends on what city you live in. Typically, this is a 60-day notice outside of or in the King County area. Let's just say, for example, in Burton. 60 days is when the notice should be for, to let you know that your rent is going to be increasing. Anything less than that is absolutely illegal. Then they also cannot evict tenants for unpaid late fees. And I know that was a thing during COVID where, everyone got a little behind and some people struggled to keep up with that. They were still charging late fees up until the law told them that they couldn't. So let's just say you were paying your rent on time and maybe there was a month or two where you got a little behind, but you were still paying your rent. And now all of a sudden you've got $75 or $100 worth of late fees. And well, you know what? You haven't paid your late fees, even though your rent's up, we're just going to have to go ahead and evict you for that. They cannot do that. Not for late fees. Anything else within that 17 reason just cause law, they cannot evict you for, right? They also cannot try to terminate your rental agreement without giving just cause under the law. And that is also in RCW 59.18.650. That states clearly some of the laws or some of the reasons why they can evict you if it's something that they are going to do at that point. Okay, next slide, please. All right, now we're going to talk about what the tenant's responsibilities are, all right? Now, we all have them. Most of us are renters, so this is something that we have to make sure that we keep in mind too and hold ourselves accountable in case that's something that you're just now learning as a renter. All right, so as outlined in RCW 59.18.130, you as the tenant are supposed to pay rent and utilities, and that is basically stating that it is supposed to be paid within that time frame that was given to you by the landlord and whatever is on your lease. Now, a side note on that one is that you cannot assert your rights as a tenant in Washington State without being up to date on your rent and your utilities. And that's something that the courts will look at is if you decide to go ahead and take them to court for that. So just a side note. Now, you should also comply with city, county, and state regulations as a tenant, even on private property or, a large property, if that's something that if you're living in like a large multifamily complex. A good example of that also is they can tow you if your tabs are expired. I've seen it before. So, that's also just a state law, right? We should always make sure that our tabs are up to date and our registrations are current. So that's something that you could get in trouble for, that the apartment community can also, give you a notice about. So just something to be aware of. And then you should also keep the rental clean and hygienic in the same condition as you first moved in, minus normal wear. And like I talked about before, normal wear is after a certain amount of time, certain amount of years, your carpets, started to mat down some, maybe it might be ripping up a little bit. So that's normal wear. Now, if it's something where you've got unruly children or, pets even at that point that are actually in there making damages, that's something that you're probably going to be responsible for most likely. So something to also keep in mind. You should properly dispose of garbage. That doesn't need to be explained any further than that. Making sure you are throwing out your trash and keeping that from becoming a bigger issue in the building as well. Now, just as I spoke about earlier, you may have to assume the costs of pest control or fumigation if it is caused by you and your unit. So please keep that in mind. And then properly operate electrical, gas, heating, plumbing, and other accessories and appliances supplied by the landlord. So just, keeping your refrigerator clean, making sure that you're not stuffing it to the brim, because that will most likely be a reason for it to stop working. So you want to make sure that you're getting behind there, you're keeping your stove together. Any sparks, anything that doesn't seem to look right or sound right coming from those appliances, you want to make sure that you're letting them know immediately. And then do not intentionally or carelessly damage the rental structure and related appurtenances. All right, so you just, again, like I said earlier, you want to make sure that you're keeping your guests, your other family members, your pets, keep them from damaging things, because you will be responsible for that if it is caused by you, the tenant. Okay, next slide, please. Okay, jumping into this one. So do not permit nuisance or common waste. That is sort of along the lines of what I just spoke about a little while ago, is keeping everyone in and out of your household that come over or visiting. You want to make sure that you let them know, hey, I live here, which is going into the do not engage in drug-related activities at any type of rental facilities. We have to do better as a community. So keep in mind that if your guests or their guests come in and do things that they're not supposed to do, it will fall back on you as the renter of that property. So just as a heads up. Going into the same thing, do not engage in any gang-related activities, please. No hazardous activity that could affect the health or safety to other people and tenants. Don't go lighting fireworks in your unit or in your home. Please don't do that. That could create an issue for a lot of people around you. So let's make sure that we're using the best judgment that we can as a renter, okay? And then maintaining your smoke detecting devices. So like I said before, making sure that you're testing them every couple of months or even every other month if you want to make sure that you're on top of it. Just make sure that your batteries are fully operational, right? And then last but not least is when you decide to leave, please make sure that you restore the rental to its initial state. Let's say there's been some discussions that didn't go in your favor in your home, and now there's holes in the wall or in the doors. Please, it doesn't take much to go and maybe Home Depot, Lowe's, get some putty, patch that over, do the best that you can so that you can get as much of your money as you can get back. Okay, that's really important, especially now that the cost of living is so much higher than it used to be. So yeah. And then normal wear, right? We already talked about what normal wear is. So your blinds, your ceiling fans, after a while, they become warped or they stop working because they're just dated and aged. Just making sure that you're letting these people know as you are living in your unit that there are things that need to be looked at, right? Now, if you have paid your cleaning fee ahead of time. So let's say, for example, you're moving in and they're telling you, all right, so we're going to charge, right now, you're going to get charged a $175 cleaning fee. They cannot charge you for another cleaning fee after you have moved out. Very important that you know that. So just keep that in mind as well. All right, next slide, please. All right, so now we're going to talk about repairs. And this is a really easy one to go through, but I want to make sure that everyone understands how to do this process and which process is the best. Okay, so according to RCW 59.18.060, the landlord has a duty to make the repairs, all right? So now this is something that I was talking about earlier, is the landlord must maintain the structural components, including but not limited to the roofs, the floors, the walls, chimneys, fireplaces, foundations, and all other structural components in reasonably good repair so as to be usable, right? And then also, the landlord must provide a reasonable program for the control of pests, insects, rodents, other pests at the initiation of the tenancy, except for the case in single-family residence. So I know this is repetitive, but this is also reiterating too that the landlord is required to provide those services to you, unless if you are living in a house. All right, and then like I said, if you are found responsible for bringing those pests in, and that could be anything from ants to roaches to bed bugs. So you can in fact be charged for that now, except in the case where you are living in an apartment community. Let's say, for example, those things travel. You want to make sure that you're letting them know as you're moving in. Actually, you know what? As you're moving in, go around to each drawer, each cabinet. If you can, look behind the refrigerators, look under the ovens if you can, look inside of the dishwasher, in the bathrooms as well. That'll be a good sign if there has been any type of activity of any sort. You will either see droppings or other dead pests underneath those areas. So it's a good idea to do that before you move in. That way, you can say that it can either it traveled from another unit or they were already there before you moved in, having your proof. And then the landlord must maintain all electrical, plumbing, heating, and other facilities and appliances supplied by him or her in reasonably good working order. Just as I spoke about earlier, is there are some refrigerators that are a little dated, stoves even, but as long as they're functioning, there's not much you can do about that. But there's also a website called Appliance 411 that you can go onto to see how old your appliance is. Now you're going to have the model number as well, and even the serial number if they have them. So it's a good idea to just look at that just in case, and then you can make your decision based on that. All right, next slide, please. There we are. Okay. So after you give a repair notice, the landlord must in fact act, okay? Now the landlord must begin repairs within 24 hours in an emergency where the defective condition deprives the tenant of hot or cold water or heat or even electricity and is imminently hazardous to life. So once again, an emergency where there's something coming from your unit or another unit above you even, or even below you, that needs immediate attention, they have 24 hours to get to that, if that is the case. Now, the landlord must begin repairs within 72 hours to fix a major appliance where the defective condition deprives the tenant of the use of a refrigerator, a stove, an oven, or any other major plumbing fixture that is supplied by the landlord. So if your refrigerator stops cooling, stops, freezing your food, and is in fact starting to melt everything, they have 72 hours to get you a remedy for that, whether it's another refrigerator from another empty unit, let's just say, or, well, I got to figure that out, but you've got 72 hours to do it. I need a refrigerator, right? Or an oven. That also does count if it's a microwave that is attached to the wall as well. Just a side note on that one. And then the landlord must begin repairs within 10 days of all other cases. Your cabinet door fell off. Your door is off the hinges. Maybe your bathroom door, your bedroom door is off the hinges. It should still be addressed, but it's not an emergency. 10 days at max, okay? And then after that, you should make sure that you're letting your landlord know, hey, it's been 11 days now, but follow it up with an email. And I'll go into this here in a few minutes as to what process is best to get your landlord's attention. Next slide, please. Okay, so now if the landlord doesn't act, you do have remedies. You've got some options here. So according to RCW 59.18.090, you can terminate your rental agreement, but it is also recommended, just like Edgar said earlier, that you speak with an attorney before you do anything that drastic, okay? You can, in fact, ask for a refund of any prepaid rent or return your deposit, or both in that case, if they do not act on these repairs. But I'm going to reiterate one more time, please, please speak to an attorney before you do this. And it's really important that you understand that you cannot withhold your rent because the repairs are not being made. You cannot do that. You have to consult with an attorney to be able to get that process going, because that's a whole nother door that you'd have to go through. So please keep that in mind. You can also seek a court order to reduce or seek mediation from a third-party organization. Now, that's best also if you decide that you do want to stay in your unit for whatever the reason is, or if you're renting a home and you do decide that you want to stay there, but you want your landlord to start getting things done, right? You can seek a court order to basically talk it out with your landlord. Hey, look, this is what's going on. This is what I'd like to see. This is what I'm trying to do as a good tenant. Let's work something out. Let's find some middle ground, okay? It's always good that we use that law where it says we have to have good faith in one another, right? As best as we can. Now, they do say in RCW 59.18.100 that you can repair the issue yourself and deduct up to 1 month's rent. But this is a really, really slippery slope to go down if you don't do this right. You can also hire someone to fix it and deduct up to 2 months' rent. The problem with this is that if you feel confident enough to replace a toilet seat or a whole toilet, and it doesn't go the way you thought it was going to go, you are going to be responsible for taking care of that bill that the landlord is most likely going to have a plumber come out and fix whatever you broke. So please be confident in your ability to do things around that home if that is what you want to do, if they're not acting on it fast enough. Now, if you hire someone to do this work for you, please make sure that they are at least licensed and bonded. Now, this could be a personal opinion or not. I'm not 100% sure on that. But you don't want to be responsible for more damage than there already is to the unit itself or to the issue that you're having itself. So just be mindful of that, please. Now, if you choose to verbally communicate this with your landlord, unfortunately, the landlord could say that this little rent discount that they gave you is non-payment. And then at that point, they can initiate the eviction process. That is the horrible little loophole that they found. I'm sure most of them have found to be able to, kick you out as a tenant if that's something that, they want to do at that point. If you're making too much noise for them, which is what a lot of landlords don't like. They just want you to, sit down, do nothing, and, pay your rent. Don't complain. So just please be careful with that process if you are deciding on doing that. You don't want to be stuck in an eviction that you had absolutely no intention on being stuck in. All right, next slide, please. All right, so the process of, okay, there we are. Sorry about that. Okay, so the process of making a repair request is basically pretty simple. You just want to follow a few rules here, a few rules of thumb, I should say, is your number one, contacting the landlord when you become aware of this problem immediately, okay? And that you should also have as much information as you can possibly give them, date, time, the actual issue itself, and keeping track of all of the stuff. You should also have the contact information for the emergency maintenance line if they have one in their apartment community, or the handyman of the private landlord that you're renting from, if that's the case. And then you absolutely want to document any type of communication that you have with that landlord. It is extremely important that you do this. But my side note of that is, please follow this up with an email or an actual written handwritten letter to that landlord, discussing the conversation that you had verbally or in person even, just to keep your ends covered. Sending in certified mail is the best. Now, that is something that you go to the actual post office for, and you let them know that you want a delivery receipt for this letter that you're sending to the landlord, because this absolutely will hold up in court once you have the amount of proof that you need, that you've tried to make them aware of this problem. And then, as I said, always make your repairs for your request for repairs in writing. It is extremely important that you email, text, sending them a certified letter, just as I said. Tenant portal is a big maybe. Not a lot of people are tech savvy with that. So if that's something that you're not 100% comfortable doing, or you're just not sure how to work that online website for the apartment community, you could still do that in writing. You don't have to do that if they tell you that you're supposed to go online and make your repair request. No, you can actually go into the office. If that's something that you have to do, go into the office, have them give you a form. Most of them do have forms. Fill it out to the best of your ability, have them timestamp that and sign it and make you a copy. Keep that copy with you in case something happens. Just like everything else in your lease or your involving your tenancy, is making sure that you have as much written documented proof as you possibly can. We don't always recommend verbal over the phone. Now, sometimes your situation will get the best of you. You might be a little upset that you don't have the attention that you're needing for this particular matter. And you may want to go and handle this in person. Well, that's something that could potentially go wrong. So it's always best that you try to remain calm, go and express it, whatever it is that you're needing to do or the work that you're needing to have done in your unit, and then follow that up, like I said earlier, with an email or even a text message, because those can be printed out too. So yeah, just no in-person or verbal if you can absolutely prevent that. If you can't, just like I said, follow it up with an email. All right, next slide. Okay, so this is where we give you all some information on where to access legal services. So the Eastside Legal Assistance Program is a wonderful program if you're living in the Renton or the Redmond, Issaquah area, Sammamish, even that far up. They also have a Spanish line too, if anyone is looking to help someone that doesn't speak English. And then the Tenant Law Center is a very good resource that we also use as well. Now, they have a King County line for everyone outside of Seattle, and then they also have a Seattle line that you're more than welcome to call. And then the Northwest Justice Project is one of our favorites. They have a lot of wonderful resources, and not just with rentals, with any other types of issues that you may be having. Let's say maybe family issues or court issues or looking for food banks or even health insurance. They're really helpful in those areas. Now, if you have received eviction papers, it's best to leave them a message at this phone number here at the bottom of the screen that you will see once you get this presentation. But if you don't, I'll give it to you. It's 206-267-7069. And then you can also email them to at hjpstaff@kcba.org. And then this is the mediation that I spoke to you all about earlier, is if you decide that you want to stay in your apartment or your rental home, but you want things to get better between you and your landlord, the Dispute Resolution Center of King County is a good place to start. And they also have a virtual intake form as well. And then if you're in the area as well of Bellevue, Redmond, Issaquah area, you can call the Bellevue Conflict Resolution Center. They are also a very good source to call in that area if you are needing some mediation. All right, next slide, please. Next slide. All right. So that's it for us, folks. Thank you so very, very much for attending this little workshop of ours. We hope to get some more people out there active and knowing and understanding their rights as tenants, because you do have them and they are yours. So please reach out to us. We are Solid Ground Tenant Services. Our message line is open Thursdays and Mondays from 10:30 a.m. to 1:30 p.m. And you can also email us too, tenantwa@solid-ground.org. Thank you all so very much for being here.